I'm Dale Smith for Loony Politics, and a Bloc MP has tabled a private member's bill that would invoke the Notwithstanding clause to override the Supreme Court of Canada's decision in the Jordan case, which deals with the hard cap on the length of criminal trials. And essentially, it would override it in the cases of certain violent offenses or murders so that they can't be stayed if they go too long. Now, for those of you who remember, the Jordan decision was where the Supreme Court of Canada said that there's a hard cap of 18 months for a trial to get started for any criminal trial because there's a charter right to have a trial within a reasonable period of time. And we've been seeing increasing court delays through all kinds of manner of issues, but a lot of them have to do with provincial under-resourcing of the court systems because the provinces administer the systems of justice. And what the Supreme Court of Canada was hoping to do with this decision was kind of give a kick in the pants to these provinces and saying, you guys need to get your acts together so that we are, so that you can deal with these court delays. And by giving them a kind of impetus that if these trials don't get done in a reasonable time, they're going to be stayed. The hope was that, the provinces would wake up and start doing things like hiring more crown prosecutors or provincial judges or justices of the peace, or building more courthouses or properly staffing them, or dealing with a lot of the back-end issues around things like not needing to have everything filed in paper and by fax and so on. And so that was kind of what they were hoping to do. But then COVID happened and it created even more delays within the court system. And the knock-on effect was that in order to meet the Jordan timelines, criminal cases were prioritized, meaning that if you have a civil case, you may now be waiting years for those to actually get heard. The other thing that happened was the Chief Justice wrote a letter to the Prime Minister saying that the federal government needs to appoint more judges faster, which is true. And the knock-on effect on that, however, was that all of the attention suddenly became on the federal appointments, and the provinces no longer getting attention, no longer needing to feel like they need to get their acts together. And while the federal government has made their appointments faster, the attention on the provinces has once again gone away. And we've seen a lot of the problems in those provinces play out, such as crown prosecutors going on strike because they have too much workload, not enough people to do it with, and not being paid enough for the workload that they have. Again, this is a provincial problem, and provinces are not taking care of it in order to get the justice system working properly. And I fear that by invoking the Notwithstanding clause on this bill, should it pass, what it will end up doing is just letting the provinces get off even more. Because again, those serious cases will no longer be stayed should this pass, which again lets the provinces off the hook, which was the whole point of the Jordan decision with the Supreme Court. So we need to remember the provinces still have work to do, and we should be putting pressure on them if we want the justice system to work properly. For Loony Politics, I'm Dale Smith.